whether you're representing the prosecution or the defense. Being aggressive, very, very important because their lives are at stake. Welcome to Injustice for All. Today we're going to be joined by a very special guest, Rick Kuiper. But I'll talk to you a little bit more about former FBI agent Rick Kuiper in a few minutes. Before we go any further, I wanted to cover a couple of topics we have been discussing in past shows, including the Ghislaine Maxwell case, and to give you an update on the events that have occurred since last week. And I was caught by a quote from T.S. Elliot the other day, which sort of embodies how I feel. And Elliot said, "Only those who risk going too far can possibly find out how far one can go." And that is the essence to being a litigator. And particularly if you're a defense attorney representing people whose lives will be impacted by what you do. Indeed, my producer, Brian Mulvaney, made a similar comment when I said to him, "Why do you think that the Daedone and Cherwitz case ended up the way it did instead of an acquittal?" And he said to me that the attorneys lacked the will to win. That's very important. You must have a will to win and to do everything, cross every T, dot every I, look for every opportunity to succeed. If you don't do that, you're doing your clients a disservice. And our guests will talk about that topic as well today. But getting back to Ghislaine Maxwell, the Department of Justice asked two different judges to unseal the grand jury testimony that related to her case and Mr. Epstein's case. The latest judge to rule on that, the one in New York, rejected the prosecutor's request, but went beyond that. And the judge sort of took it to the Department of Justice by saying that there was nothing in the grand jury testimony that was more than the garden variety type of material where two agents testified in summary form to what they had learned. And all of that information was revealed at Ghislaine Maxwell's trial. So it was sort of trying to put a Band-Aid on this whole issue. The judge went on and to say they did not discuss in the grand jury testimony or identify any client of Epstein's or Maxwell. They did not reveal new sources of their wealth. They did not explore the circumstances of Epstein's death. A member of the public appreciating that the grand jury materials do not contribute anything to public knowledge might conclude that the government's motion for their unsealing was aimed not at transparency, but diversion, aimed not at full disclosure, but at the illusion of such. And I think that says it all about that. The files, whatever those files may be, the Department of Justice will ultimately decide to release or not release. What they contain, who they make allegations against, we don't know. But it's become a tempest in a teapot here because we have all of these moving parts. Ghislaine getting moved out of the Tallahassee facility over to a camp in Texas, Bryan Camp, the possibility of a pardon being dangled before her. There's a lot going on. And it would be so much easier and would put this whole thing to rest if they just released whatever they had and let the chips fall where they may for everybody. Democrats, Republicans, public figures, private citizens. Why are we continuing to talk about this? Now, another thing that's come out that's of interest is while the Department of Justice said that there was only 1 minute missing of the videotape of Epstein's cell on the night he committed suicide or died, we now know that there were 3 minutes. And in addition to the 3 minutes, we know that before those 3 minutes and the rest of the video were provided to the public, that it went through what we call an Adobe Premiere edit. We don't know the metadata on that edit, but we do know that it was edited. So that remains an open issue. Another interesting development this past week was that the Department of Justice hired as an advisor to the Department of Justice, a former defendant in the January 6th prosecution. And this was a fellow who had been prosecuted he was a former FBI agent, by the way, who had been there and is heard on videotape and seen on videotape saying to the others who were there, pointing towards the line of Capitol Police who were there, kill them, kill them, kill them. But now he's elevated to the Department of Justice as an advisor. Now, our guest today is Rick Kuiper. Rick spent 20 years with the FBI, became their expert for computer analysis response team. That's called CART. And he'll explain what that means. But essentially, almost every agency, federal investigative agency, has specialized people who deal with different types of evidence they collect. Rick's expertise is in the collection of hard drives, computers, and things of that nature. And the FBI has a program in place which says to the agents, if you collect such an item, you must turn it over to CART. Don't you look at it. Don't you touch it. We're the ones who are supposed to look at it. Anyway, that's part of what he's going to be talking about today. Now, and in addition to have Rick explain the generalities of what CART does, he's going to talk about the specific case that I asked him to look at, which is the prosecution of Nicole Daedone and Rachel Cherwitz. And he has written an extensive letter analyzing all that went on by the agents, particularly an agent named McGinnis and one by the name of I can't think of his name at the moment, but he'll come back to me. But the two agents who were the principal people on the case seem to have done a number of improper things with the evidence that they were collecting, and we're going to be talking about that. Schmidt. So Rick is going to talk about.
1 second. Did your phone go off? I swear to God, I heard something.
It did.
Okay. You want to just turn it off while you're doing
Yeah,
this?
let's do that.
Okay, so then maybe start from introducing Kiper, because it was going off during that time. Do you want me to do it?
I can.
Don't put it back there. Yeah, that's good. And maybe start from today.
Tell me when you're ready. So today we're going to have Rick Kuiper, as I mentioned a few minutes ago, former FBI agent and who's been in private practice dealing with security issues, recording issues. Rick was the teacher within the FBI. He taught not only at Quantico, but he taught the instructors who taught at Quantico. So he's the pinnacle on this topic. And among the things that Rick is going to talk about today is a case, the prosecution of Nicole Daedone and Rachel Cherwitz. And I asked him to look at that with a view towards what the two principal agents, McGinnis and Schmidt, had done in their collection of evidence, specifically hard drives and the like. And he has written an extensive letter to me with regard to that. We're going to go through that letter today, and I hope you'll understand that the reason we're going into this kind of discussion is so you understand all the working parts of the criminal justice system. We're not just going to hear from people who have been falsely accused, went to prison, and then were exonerated. In order for you to understand the entirety of the system, you need to understand its components. And one of the components is how our law enforcement agents work and what they're supposed to do, what they don't do. And Rick is going to be part of that equation today. We're about to be joined now by Rick Kuiper. Rick, how are you?
Doing well. Thank you. And thanks for inviting me.
So tell the people who you are.
My name's Rick Kuiper. I am a retired FBI agent, forensic examiner. I spent 20 years with the FBI before I retired in 2019. When I was in the FBI, I served as a special agent investigator. I had my own cases, did a lot of white-collar crime, organized crime. I went to San Salvador as the assistant legal attaché to start that office. I started in Miami, and then I went to headquarters to work on the FBI's case management system. At that time, 2002, the FBI was still using paper as its system of record, and so we went to go change that, and that became what we know now as Sentinel, the case management system. Came back to Miami, went to El Salvador as assistant legal attaché. Came back to Miami. I ran the confidential human source program. That's what we call it now. It used to be called confidential informants or cooperating witnesses, but those people, those assets that the FBI uses in cases. And then I went to become a CART forensic examiner. So computers have always been my background, but I finally got the chance in 2007-ish to join the computer analysis response team for the FBI. We call it CART for short.
So before we get into a further definition of that, you always hear FBI agents referred to as special agent this, special agent that. Is everybody in the FBI a special agent?
No. At the time that I served, we had about 14,000 agents. And the special agents, what makes special agents special is that, we carry guns and we have the power to arrest people. And but of course, it's just like the military. You have, people that actually are involved in the action of, killing people and breaking things, as the Army says. And then you have those who support those who kill people and break things. So the same thing in the FBI. We have those who actually do the investigation, make arrests, execute search warrants, and then we have those who support us who do that. So we have secretaries, we have file managers, and we have intelligence analysts as well who work more with the intelligence that inform some of our criminal actions, as well as making sure we keep the homeland safe, from terrorism and things like that. So yeah, it's a wide variety of employees in the FBI.
But the guys and women who carry weapons and make arrests that we traditionally know as the FBI, they're all special agents.
That's correct, yes.
So you mentioned CART, and we're going to get into the confidential assets a little bit later in the program, but you mentioned CART. Explain to us what that means and what you did there and what it is intended to do.
Sure. The computer analysis response team is one of many response teams in the FBI that special agents and also professional support can apply to do certain specialized things. We have evidence response team, ERT. We have hazardous materials response team. So CART is specializes in digital evidence. So what we do is we assist cases and case agents in the identification and the collection and the preservation and the examination and the analysis and the reporting or presentation of digital forensic evidence. Any of the forensics job families, and we have, trace evidence and fingerprints and all that, but all of the forensics, what forensics means is it means that the output of what you're doing is going to be presented at trial or some other legal forum. So that's what forensics means. And it's a very tight set of standard operating procedures that we must follow to make sure that what we're doing is suitable for trial.
Why did they create CART?
Well, the CART was created, probably 1997, right before I came into the FBI. And that's because computers started to become very ubiquitous. I mean, we see it everywhere. Of course, today it's even worse. I mean, every criminal of every federal violation has a cell phone, a laptop, a desktop, a tablet, a drone. Email accounts. Everybody uses this stuff now, even the bad guys. So the need arose for people to be trained in extracting data from these devices forensically, so that we can take these cases to trial and use this digital evidence.
So how would an individual agent, special agent, who's not part of the CART team or any of the other teams you've mentioned to us, how would they know about your existence and the requirement to utilize you?
Well, everyone that goes through orientation in the FBI receives many, many hours, days of training, depending on what their job is. And it fluctuates from year to year. When I went through, it was like 4 months or 4.5 months of training at the FBI Academy. But everyone goes through some sort of onboarding process where they are introduced to all of the resources that are available in the FBI. So you have somebody coming in from records management division, and they may talk about how we manage records in the FBI with Sentinel. They may train on Sentinel, which is the case management system. You have people coming in from evidence response team. As a special agent, we're trained hands-on on a lot of these things. We're trained to collect evidence. It's actually on our credentials, that we have the ability to collect evidence ourselves. But sometimes if it's a huge job, we'll bring in the evidence response team, or if we know we're going to encounter a lot of electronic devices, we'll bring in the CART forensic examiners to help identify those items that need to be seized, within the scope of the search warrant. But everybody that goes through that comes into the FBI gets some sort of orientation that tells them that, hey, one of the resources you can use is CART. And when I was a special agent doing my own investigations, white collar crime, organized crime, I knew about CART and I interfaced with CART. On one of my cases, we had 10 search warrant locations and 22 seizure warrant locations. And it was a lot of coordination, and not just with the FBI, but I, brought in people from our task forces and our liaisons, and we had over 100 people involved in this takedown telemarketing scheme. But part of that was collecting the digital devices, the computers. And so the CART team did what they were supposed to do. They collected, they preserved it, and we can kind of go through what each of these stages mean. Identification, collection, preservation, examination, etc. But I saw the output of what they did for me as an investigator, and then eventually I became one of them that helped other investigators do their cases.
So if I know I'm going to be collecting computers or getting a hard drive or whatever it may be, is an agent supposed to contact CART, or after they collect it, are they supposed to give that evidence to CART?
It really is up to the case agent, the case manager, or the case owner as to what they would like to do. Generally, if they know there's a lot of computer equipment, they would bring CART, and they would put a request into our system. We call it a CART request, and then it gets routed to the CART supervisor, who then assigns that to someone to help go out with the team to help them identify those things and possibly make forensic images on scene. So for example, the city of Opelika was under investigation. Several people in the city of Opelika, Florida. It's in the Miami area, and I was head of the team at that time, and all of our examiners, I think there were 12 of us at the time, we all went there and we all imaged on site every computer device in the city of Opelika. Of course, they shut down for the day, but we couldn't shut them down. You could, by taking all of their equipment, the city still has to run. So in that case, we had to sit there from 4 o'clock in the morning on one day till almost 4 o'clock in the morning the next day, doing nothing but copying the digital data from their servers and laptops and desktops and other devices. So sometimes we have to do that in hospitals. We always do that. There's no way we can shut down a hospital, but if some individual doctor or employee isn't involved in a crime, we can go in and image, what we call image, which means making a bit for bit copy of a device, extracting all the data, including the deleted data. And so we'll do that on scene rather than take it. But if it's like say it's a drug case or something, and the case agent says, you know what, we have the authority to take their cell phones and take their laptops and everything. We're just going to take it, and we're going to bring it back, put it into evidence, and then we'll put in a request for CART to check it out of evidence and to conduct their examination at that point.
So the agent sees the phones in your example that you just gave us. They bring it back, they put it into evidence, they put in a request to CART. At that point, they're supposed to leave the job to CART to do the analysis. Yes?
That's correct. As a matter of fact, according to the Digital Evidence Policy Guide, that's the FBI's overarching guide on digital evidence, only trained and certified personnel are allowed to do any review of digital evidence. So when you see in the chain of custody, as I've seen in some cases that I've had recently, where people are checking a device out for review, and these people are not CART examiners, they're not CART certified, they don't have the equipment to be able to preserve the evidence. And specifically, I'm talking about a write blocking device, which you connect the original evidence to a write blocking device, and then you connect that write blocking device to the reviewing machine or the examination machine. And the write blocking device prevents anything from the host machine to make any kind of changes or modifications on the original evidence. And if you don't do that, you are necessarily going to change the evidence, because if you just plug in a thumb drive to your laptop, there are changes that are made. You don't see them maybe, but changes are being made and the same with a hard drive. You take a hard drive, an external hard drive, and you plug it in. As soon as you plug it in, the computer starts talking to the hard drive, starts making modifications, and that's problematic because then you're starting to change the evidence, and we don't want to do that.
I mean, among other things, if you put in a thumb drive and you open up the thumb drive, you could be changing the dates of when the file was created or when the file was last closed or things of that nature.
Absolutely. Just opening a folder and looking at the thumbnails. Maybe the thumbnails weren't even there, and you're creating them by opening the folder. And you can change the access dates as well just by looking at the folder. So and it depends on the file system. There's NTFS for Windows, and there's Apple file system for Apple machines, but and then there's Unix, of course, and they all work a little bit differently. But yes, there's always the danger just by looking at it. You can change it if you don't use a write blocker. And that's why it's called a critical procedure in the FBI. I used to teach in that program. I helped develop part of the curriculum, and I taught many of the teachers in that program. So we really are, in the FBI, we make it a point to follow these procedures to the T. And if somebody is not using a write blocker to view evidence, we'll know because we'll see that the evidence has been changed, and that's an automatic fail.
And when you say an automatic fail as a student or automatic fail as a case agent in the street?
Well, whoever's being trained. So we train case agents like myself decide, hey, we want to, we have some computer skills. We want to be part of the CART team. So we apply and we go through a bunch of training to get to the point where we can actually handle digital forensic evidence responsibly. But professional support people could also do that if they have a computer background. There are some. To get into the program, you have to have a college degree, and the college degree needs to be including courses and some hard sciences like physics and chemistry, and there's certain math courses you have to have. So there is kind of a filter for people to get into the program, and then once you're in the program, hey, you may know about computers, but can you follow our procedures to make sure that the data that you are reviewing and examining and exporting is suitable for trial purposes, and it's not going to get excluded at trial?
And by excluded could mean that something's happened to the evidence in the chain of evidence that causes a judge to say, well, you screwed up.
Yes. If there's, if you get to trial and you can show that the chain of evidence was broken, or maybe someone checked it out that wasn't certified and they reviewed it, and you look at the evidence itself and you see, as in the case we discussed earlier, U.S. versus Keith Raniere, you can see that the last accessed dates have been updated on all of the active files on a particular camera card, and that happened 6 months after it was seized by the FBI. So we know somebody in the FBI actually looked at that card without a write blocker, and those are last access dates. That doesn't mean that's the only time it was accessed. Every time that you access it, it keeps updating that date. So it could have been multiple people accessing the card. And if you look at the chain of custody in this case, you look at the chain of custody for that camera card, multiple people checked it out for quote unquote review. And it's really interesting because in this case, in the Raniere case, the FBI finally had to admit, the government admitted, yes, It was modified while in our custody, but we didn't do it for nefarious reasons, as the defendant says. We we did it because we didn't think. You know what? I'm going to read it to you. I think I have it right here. If I could, can I do that, Robert?
Surely.
It's just a couple of sentences, but it's outrageous. Okay. This is the government's opposition to the Rule 33 motion from the defense for a new trial. But so here's what they said, quote, "This access was not the result of law enforcement tampering, as Raniere's motion claims. Rather, having no reason to believe that the metadata of the contents of the camera card had any evidentiary value, law enforcement agents directed that a photograph technician copy the photographs from the camera card in order to provide the photographs more expeditiously to defense counsel," unquote. So that is, in this, they are admitting that they intentionally circumvented the CART process, okay, where CART is supposed to get it first so they can preserve it, and then people can review it and examine it. That was circumvented. They intentionally gave it to a person who was not trained to preserve it. Okay, some photograph technician. They intentionally left this person off of the chain of custody. This person doesn't even appear in the chain of custody, but they are the ones that altered the evidence, the original evidence, and they intentionally withheld this person's name in this whole incident at trial. And now, in this paragraph, they're declaring that metadata has no evidentiary value. But let me tell you, at trial, it was the metadata on the set of photographs that was found on an external hard drive. It was the metadata on those photographs that they used to illustrate or to prove that the photographs were taken in a certain time frame, which made the subject of those photographs female, 15 years old, and therefore the photographs would be considered CSAM or child pornography. So that was their whole metadata, was their whole case to prove the dating of the photographs, which, by the way, is very easy to change. But then here, because we caught them accessing the camera card, which was used to connect to those CSAM images, they're saying that the metadata on the camera card doesn't matter, and so they gave it to somebody who wasn't qualified, and they accessed it, and they didn't use a write blocker, but so what?
And you've broken this down for us, but actually it's a little more complex in that case. It put the taking of the photographs and the location of them at a particular address where Mr. Raniere supposedly had access to them. So they were connecting the dots to make him the person who had the photographs.
Right, and not only that, but even given that the photographs, I didn't see the photographs because they're considered CSAM. Child sexual exploitation, child sexual abuse material is what they're calling it now. We call it child pornography, but basically, the photographs themselves at trial, they could not determine from the content of the photographs the age of the person. So that's why they had to rely on the metadata, specifically the timestamps, to age the photographs. Like, yes, this looks like a fully grown woman, a mature woman, but because of the dates on the photograph, she was only 15 years old, and therefore this is child pornography. And based on that, Mr. Raniere was sentenced to 120 years in prison.
Right. And as you mentioned a moment ago, one of the things that prosecutors intentionally did was to leave out that middle person who was not authorized, was not a member of CART, in what they were presenting to the defense. So the defense would have no way of knowing, hey, there's a missing person in the link here.
That's exactly right. That person, and they still won't identify her. I know who she is because when they did give it to this person, and she extracted the photographs from the card and she made PDFs out of them. Okay, PDF documents out of them, and that was given to the defense instead of the original camera card, which is always, you know, forensically imaged, and then the copy, the forensic copy, or the forensic image we call it, that image is always given to the defense. If you're going to use it at trial, the defense gets access to the evidence that is going to be used against him. And in every other device that was seized, every single other one in this case, they made an image and they gave it to the defense, with the exception of this card. This card, they still, to this day, even though, you know, that we're in post-trial right now, but they still will not give the forensic copy of the camera card. And actually, it's a little bit worse than that, because what they did is they made two forensic copies. Okay, one forensic examiner that was originally assigned to the camera card, he made a forensic copy. He made a forensic report. He extracted some photographs and he made a forensic report. And then, you know, during trial, you know, 4 weeks went by. They never used him. They never brought him up. And all of a sudden, that guy, the forensic examiner, got an assignment to go to Africa. And then a new forensic examiner came in. But instead of using the forensic copy that the first forensic examiner made, he took the original evidence, which he received in an unsealed plastic baggie. Okay, he took that and he made his own forensic copy. Okay, or forensic image. So there are actually two forensic images. And he made his own report, and his report had more photographs than the first report that connect back to the external hard drive. So there's all kinds of things that got messed up in this case. But really, the smoking gun was the discovery, or the admission, of this photograph technician that was unidentified. The person was not trained to do what she did, and she ended up altering the evidence. The government in this case, you know, they have no problem with that, apparently.
Well, so taking you back for a moment and your credentials, you mentioned that you joined this team in the FBI. How long were you with the CART team?
Oh, let's see. That would be 12 years just with CART. But before that, of course, I was interfacing with CART, very close to them, you know, in the cases that I was doing. But I did 12 years as a CART examiner and teacher and curriculum developer.
And you taught this at what we call Quantico, correct?
Yes, almost all the training that we did when I was in the FBI, almost all the training was done in centralized in Quantico. Sometimes we taught classes in one of the regional crime forensic laboratories, RCFLs, but in some kind of controlled space.
And would you oversee in that capacity the individual CART offices around the country?
That wasn't my job. Now, there is a CART headquarters unit which oversees the program itself. So, for example, a lot of the administrative things like, okay, you know, what is the budget for this year? According to the budget, you know, can we go out and refresh the desktop examination computers? Can we send out more write blockers? Excuse me. Can we send out more removable media, Blu-rays and things like that? So those people support what's going on in the field. And then there's another group also at headquarters that they control the policy. Okay, so you have CART SOPs, and you have the Digital Evidence Laboratory, what they call the Digital Evidence Laboratory, Quality Assurance Manual as well. So there's quality assurance, and then there's SOPs, you know, setting the standards for what forensic examiners or CART examiners are expected to do.
Now, is there anything, talking about Raniere for the moment, anything else unique about the CART office in New York that distinguishes it from CART offices elsewhere?
Yes. Usually a field office will have their CART team, okay, or sometimes there's a whole unit. Larger field office, you have a whole unit for CART. Smaller field offices, they may have one or two CART people, but they have a space, a secure space within the field office, okay? During the Raniere case, at least, the CART people, the CART forensic examiners, were actually off-site. They are away from the main office, and so it just adds a little more complexity to, who goes and checks out the evidence to be examined. In the regular, almost every other field office that I know of, it's the examiner that is assigned the examination. They go and they assign the chain of custody at the evidence control room. They sign the chain of custody and they take out the device, and so it's under their control. They go back to the lab and they conduct their forensic examination. But in New York, sometimes the case agents would go and check it out and then transport it to the forensic examiner. And it's if it's done quickly, like the same day, it's usually not a problem. But when the person checks out the evidence and then keeps it for a couple of weeks, you start to question, like, okay, what's going on here? Why is that person who is not certified to review the digital evidence, why are they holding on to it for so long before they give it to CART?
So for those who have not seen CSI or similar type programs, you talked about the chain of custody. What is that?
The chain of custody is a document that records, first of all, who collected it. Okay, so as soon as the device becomes a piece of evidence, someone fills out a form and it says, I encountered this, I collected it, and that's the first person in this chain. And so that person then relinquishes the evidence to the next person. So let's say someone collects it at a search site. What's supposed to happen is they go back to the field office and they enter that evidence into a centralized evidence control room. And then the person that is receiving that at the evidence control room, they also sign it as receiving it. So you have the person giving the evidence as the person who relinquishes it, and they have to sign their name, date and time, and the reason. And then the person receiving it also signs their name, date and time, and the reason that they're receiving it. In the case of evidence control room, they're receiving it for storage. In the case of a CART examiner checking it out of evidence, they're checking it out for an exam. So sometimes they check it out to transport it to trial. Okay, so those are all legitimate reasons to handle the evidence.
Well, you mentioned a few minutes ago about the open bag in the Raniere case. What did you mean by that? Open bag, closed bag? What does that mean?
Sure. So when evidence is encountered and it's seized, it is, by our requirements, by our SOPs, we have to package it and label it.
Standard operating procedures.
Standard operating procedures. That's right. Yes. Just like in the military, everybody has standard operating procedures. But according to ours, when we encounter something that we're going to seize, not only do we take a photograph of it in place, and if it's got a serial number, we'll turn it over and capture that serial number also. But then we'll package it and label it in such a way that the packaging is tamper-proof. Okay, we have special tamper-proof tape that we apply, and then we label it with the case number, the number, what we call the universal case file number for the case, the date, the person who seized it, their initials, and some unique number. Okay, so if it's a serial number, that's unique. Otherwise, in some offices, they apply a barcode. Okay, that's a unique number as well. So something that uniquely identifies that piece of evidence, so that if it gets mixed up somehow, it can get back to the right case, and then you know what you encountered. And all of this, of course, is logged. So when this goes into evidence, when it goes into the evidence control room, they take all of this, they sign the chain of custody, and it's also tracked electronically as well. So you have the paper copy and you have the electronic copy. But then when the CART examiner receives that evidence, it still needs to be sealed. Okay, so, and if it was opened by somebody else, that person has to reseal it with their initials and their date that they resealed it. Okay, so that way the person in the chain, that there's a person in the chain of custody who actually handled this, and they opened it and they resealed it, and here's the person. Okay, when in the Raniere case, the second forensic examiner received a camera and the camera card in an open box, wasn't sealed, and then the camera card was in a baggie that also was not sealed. So that the forensic examiner has no idea who unsealed it, because at some point it was sealed. Who unsealed it, and what did they do with it? There's no way of knowing. And that came out at trial too. And I don't know why at that point that evidence was not excluded, because that's pretty bad when you're, well, and it's actually worse. The forensic examiner who testified at trial was the second one. And he said, yes, he admitted he received it in an unsealed baggie. He didn't put that in his notes, but he admitted it on the stand because they found out some other way. But then he was asked, is this something that normally happens? And he said, yeah, it happens all the time. It doesn't have to be sealed. He lied on the stand, and he said that that normally that it's not required for evidence to be sealed when it comes to the forensic examiner. That is patently untrue. The only time that we receive evidence without a chain of custody and without something being, if it's being sealed, the only time that happens is exigent circumstances, which means it's an emergency. Somehow there's a child who's gone missing, or there's a ticking time bomb somewhere. Okay, we will receive the evidence and start our examination immediately, and then everything else will follow. But that didn't happen in this case, and there was really no reason.
Let me ask you this. The agent admits that this is the norm, so to speak. He admits that it was an unsealed bag. What were the consequences to the agents for not having followed procedure?
Well, that's part of the problem. That's part of the problem, is that I don't think anything negative happened to them. I'm not part of the FBI anymore. I'm not privy to what's going on in particular units, but this case should be one of those cases that we review with the incoming forensic examiners to teach them what not to do. For all agents in the FBI, we go through legal training every quarter. And every time we receive legal training, we get a case or two of where the FBI screwed up. Either somebody wasn't Mirandized correctly, or, something happened where it was detrimental to the case, and they teach us that. This should be a case that is taught to everybody.
So let me take that a step further. The defense ultimately pointed this all up to the trial judge after the conviction. Did the trial judge say, oh my God, I got to set aside the guilty decision by the jury and give him a new trial?
No, that's not at all what happened. The trial judge in this case He said, well, it wasn't outcome determinative. Okay. In other words, he said this wouldn't have made a difference in the case because there were testimonial evidence. There's all this other lines of evidence. So the fact that this forensic snafu happened really wasn't outcome determinative, and so he just let it slide.
Did he hold a hearing before making that decision?
No, as a matter of fact, we have been requesting an evidence hearing so we can get to the bottom of a lot of these things. And that's only scratching the surface of the Raniere case. There are a lot of other things that went wrong, but we've been asking for evidence hearing on this. Alan Dershowitz, who is also assigned as counsel to this case, has called for it repeatedly because there's always going to be this question about how the FBI handled the digital evidence in this case, which was at the core, at the heart of what it took to convict Mr. Raniere.
So at the beginning of April of this year, I contacted you to ask you to look at another case, correct?
Yes.
And one of the reasons I mentioned having you involved was that one of the agents in Raniere, Agent Elliot McGinnis, also seemed to have his footprint on the collection of forensic evidence in the prosecution of Nicole Daedone and Rachel Cherwitz, correct?
Yes.
So did you begin to do an analysis of what happened in Daedone and Sherwood with regard to the collection of a hard drive and other evidence that the government used against them?
Yes, I did. And Mr. McGinnis, in the Raniere case, appeared in the chain of custody as a kind of a transitory person who might have checked it out of evidence and then given it to the forensic examiner, or maybe gave it to another agent who then gave it to the forensic examiner. Passed through a lot of hands. And by the way, that's one of the reasons why receiving something in an unsealed, unsigned package is problematic when you see that it's gone through so many hands. Okay, and that someone altered the evidence because of the forensics. Someone altered the evidence. So it's problematic on many levels. But Mr. McGinnis, in this second case that you brought up, had a lot stronger role in the case. He checked out, collected the evidence, but held onto it for, I think it was 10 weeks before giving it to CART, which is, to me, outrageous. I mean, you don't want that kind of liability. As soon as you collect digital evidence, it needs to go either straight to CART or straight to the evidence control room. And this guy had it for a long time. And then he finally gave it to CART. I can't remember the exact chain of custody, but he ended up checking it out several times, even after he gave it to CART. And if CART followed procedure, as soon as they received this evidence, they would have connected it to a write blocker, looked at it, in their examination machine, and made a bit for bit forensic copy of it. And then once that happens, once the bit for bit forensic copy, what we call the forensic image, once that is made, you don't touch the original evidence ever again. You just keep it in evidence control, and you do all of your work with that copy, because that copy is a bit-for-bit copy. It's an exact replica, represents every piece of data, every one and every zero that was on that device. So you don't touch the device anymore. You only work with the forensic image at that point. You point your tools at it. You can review the evidence. We bring it into a tool called FTK, Forensic Toolkit, where and we can make that available to case agents where they can bookmark those items that are relevant to the case, and then we can extract that data, those files that are relevant to the case, and create a report out of it. That's how the system is supposed to work. But in this case, McGinnis, he checked it out multiple times, even after he gave it to Cart, which is crazy. Why would you touch the original evidence after Cart has already received it? So one of the things we were asking for in this case was a forensic copy of that device so that we can see whether or not it was accessed and whether it was altered. We know it was accessed during the 10 weeks because he said in an email, I think I even have it here. He said in his own words, he attempted to review the files on the hard drive, but it failed to load. So he connected it. He took it upon himself to connect it to whatever computer he had, probably one connected to our secret network, which is really a big no-no. You don't ever connect evidence to our network. CART has a special network that we review all evidence. But he attempted to review the files on the hard drive, but it failed to load. He put that right into an email. So we know he looked at it when he wasn't trained to do it. He wasn't authorized to do it. CART had not had a chance to preserve it. And very likely, if he just connected it, he altered it somehow. Even unintentionally, he altered it.
So in addition to that faux pas, so to speak, on McGinnis's part, when he learned of forensic evidence, hard drives that existed, rather than shipping them anywhere else, he asked for, as you may recall, them to be sent to him and for him to have editing rights. What, is that appropriate?
It is never, ever appropriate for someone who is untrained and unauthorized, and it would only be a CART examiner, or in some cases, there's kind of a lesser examiner job called a CART tech or a CART technician. They have limited powers. They can use write blockers. They can review evidence. They can even do a very simple search, find, and extract using some of the tools. But they are not fully certified. They can't offer expert testimony, for example. But there's no indication that Mr. McGinnis has any training at all in any of this. You would think that if he was a CART tech, that would be front and center, right? Or if he was a CART examiner, even. I mean, this is something that would have been disclosed, and then you would say, okay, he was authorized to do all this, but he wasn't. He was. It seems to me all indications are this is just a regular grunt agent who wanted to preview all this stuff. And previewing is explicitly forbidden in the Digital Evidence Policy Guide for anyone who was not authorized to review digital evidence.
And when he learned of, you can tell us whether this is appropriate or not, when he learned that there might be additional evidence, journals that might exist, handwritten journals, typed journals, he had them sent to him by UPS rather than having an agent at the location, the state where the evidence was, pick it up. How was that fit into procedures in the FBI?
Yes. Well, normally if we have someone in the jurisdiction of another field office who needs to be either interviewed or needs to have evidence collected, evidence that you're going to use, we send what's called a lead. The FBI sends a lead, which is like a task order or a request for work to be done, to that field office with a description of who it is that needs to be interviewed or needs to provide evidence, and and what to ask them, and then or in this case, what evidence needs to be collected and then shipped back via Federal Express and tracking numbers and things like that. Depending on what kind of evidence it is, it could use our internal system to do it instead of UPS or FedEx. But anyway, it's done via other people, other FBI operatives on the other side. They do the work and they send it back. And if it's evidence, okay, especially digital evidence, it is packaged in a certain way, and it is sent not to the agent, it's sent to the evidence control room. And as a matter of fact, the person collecting the digital evidence will put it into their control room at their field office, and then it's a control room to control room transfer, and that keeps it out of the agent's hands and makes the chain of custody a lot cleaner.
So it seems like Agent McGinnis and the other FBI agents potentially in the case screwed up.
Yes, and it's hard to discern sometimes between screwing up and someone who is doing something in an intentional way, being intentionally nefarious. Because I have known FBI employees to be incompetent. There are some of those, and sloppy, but and mistakes are made all the time. By the way, someone on my squad in Miami was examining a cell phone, and while when you examine a cell phone, the cell phone actually has to be on. In most cases, it has to be on so that you can create a trust relationship with the examination computer and you can extract information. In handling this cell phone, this forensic examiner accidentally took a picture of himself with the evidence phone. Okay, so that's embarrassing, but he did the right thing. He admitted it. He documented it. He said, this was inadvertent. Realizing that he overwrote a little bit of the data that was on the phone, but he admitted it, and it was all out in the open, so that the jury, if they thought this was really bad, that at least they would have had the information. But hiding things when things are messed up, when things are altered, like in the Raniere case, when it was altered and you don't admit it, and then when you do admit it, when you're forced to admit it, you claim that, well, you did it because you didn't think the metadata evidence was important, and you left that person off of the chain of custody, and you don't identify the person, and it's just like the cover-up is worse than the actual sin, right?
Right. So referring to your letter, I see where you wrote, that is your letter to us regarding your examination in the Daedone and Cherwitz case. You wrote that in his communications, I did not observe Special Agent McGinnis identify himself as a special agent, forensic examiner, SA/FE, nor did I see that he was authorized to review original digital evidence as a CART tech who was trained in digital evidence preservation. Why is that so significant?
Well, because in none of his emails, usually if you have a certification, and you have a certain job title, or you've had certain training, usually you would put that in your signature block, right? Like, hey, I'm a CART tech. You put that in your signature block. But in any of the communications that I saw, at no point did I see in the signature block or in any other of the communications where he identified himself as either a CART examiner or a CART technician who would be authorized to view the evidence the way he did.
I don't want to leave Agent McGinnis out on a limb by himself, because he wasn't the only FBI agent in the Daedone and Sherwood prosecution who mishandled evidence. Is that correct?
I would have to review the facts in this case. Maybe you can. refresh my recollection.
So you were writing about Special Agent Daniel Schmidt, and this is on the third page of your letter, towards the bottom,
Okay.
where you're talking about.
Okay. He was the affiant. Okay.
Yeah. Okay. So you can read that to yourself, but what I'm alluding to is that you also found that Agent Schmidt, Daniel Schmidt, had taken evidence and kept it in his possession for more than a week. That's the last paragraph on the bottom of the page. So read that to yourself, and then maybe you can tell us what you saw happen and why it was appropriate or inappropriate.
Yeah, I see. At the beginning, he had checked out. We're talking about a hard drive, a Western Digital hard drive. At this point, he checked it out, and then he turned it over to a forensic examiner, which is, good, almost immediately. And then the examiner kept the device until the following day. Now, if you're a forensic examiner and you have a piece and you have a device that's given to you, really the first thing that you do is preserve it. That's one of the big phases of the digital forensics process: identification, collection, preservation. And so the very first thing he should have done when he received it is to preserve it. And he did keep it until the next day. The forensic examiner did. So basically any subsequent checking out of the original device is completely unnecessary and should be called into question, because now you have a forensic copy, which should have been made. So Schmidt checked it out. He checked out the original evidence after he gave it to CART, and it went back into the evidence control room. He checked out the hard drive, the original hard drive, again, and kept it for more than a week. You're right. There was absolutely no reason for him to do that. He could have done anything with that. Now, it's possible that the forensic examiner did not make a forensic copy. Maybe they just previewed it and said, okay, nothing to see here, or hey, let me know when you want to do a full exam. Maybe that's what happened. I'm being charitable. If that's what happened, then the forensic examiner didn't do what he was supposed to do. But anyway, so he checks it out, and again, Schmidt has no authority to review it. Like, why would you check out a hard drive as an agent who has no authority to connect it to a computer to review it? Why would you check it out? You're going to dust it for fingerprints? I mean, there's no reason to do it. It's a container of digital data that you can't get to, so why check it out? That's very problematic. And in what I recorded here in my notes here is that he gave no operational reason in the chain of custody why he checked it out. Let's see. Yeah, so and then he turned it over to the card examiner again, and again the card examiner kept it for a day. And again, it's another opportunity to make a forensic image so you don't keep messing with the original hard drive. Now, so this whole, continuous checking out of the original digital evidence, raises questions, like, why are you doing this? Why are you checking out the original digital evidence? I can understand if this was say it was a photograph, a printed photograph, or maybe a box of documents that they check out, and they want to review something, they put it back. You're authorized to do that. You have the ability to do that. But if you're checking out digital evidence and there's no way for you to actually get into the device and review the data there, then you have to ask the question, why did you do it? You can't get into it. So anyway,
and
yeah.
What would you speculate could be a reason that an agent, knowing he can't get in, would try to access digital information?
Well, there's a nefarious and then there's a non-nefarious reason. Nefarious reason would be he wants to delete things that are exculpatory, or alter things that are that almost I never hear of that happening. Okay, someone intentionally in the FBI intentionally altering the evidence. The non-nefarious reason would be he wanted to see for himself. He wanted just to connect it to his desktop at his at his desk and review it and maybe take some screenshots or take some notes or something. But in doing that, most likely he altered the evidence just by the very nature of the two devices connecting to each other, not through a write blocker.
So, did you reach any conclusions about the actions of Agent McGinnis and Schmidt and the FBI in general with respect to the evidence in the Daedone and Cherwitz case?
Yeah, well, I mean, I had 4 findings. The first 2 findings were basically pointing out the problematic handling of this evidence. And then the second 2 findings were my assessment of what could be on that hard drive if that hard drive were to be turned over to the defense like it should be. So yes, we pointed out a lot of things that were wrong in the handling of it. But also I said, if a forensic image were to be provided to the defense and then provided to me, I could determine whether or not it was altered, when it was accessed, and all of that. And there's a lot of different ways to do it, and I list those different reasons. But also there could be exculpatory information that they want to retain, and maybe that's why it wasn't provided to the defense.
In neither case, that's a very good reason to withhold it.
In the Raniere case, it's the same thing. They will not provide either of the forensic copies of that camera card, and they don't even provide a good reason. They just said, well, you could have asked for it during trial. Well, they did. They asked for forensic images of everything, and they withheld that one thing, but they didn't make a big deal of it at trial, is what they're saying. That, well, you should have brought it up at trial. You're not entitled to it at this point.
Well, to complete the circle of deception, so just to make the point here, in your business now, private consultant, is this the kind of thing that you can do for attorneys like in the Raniere case and Daedone, Cherwitz, etc.?
Sure, absolutely. I mean, because of my background in the hands-on part of being a CART forensic examiner, I know the technical issues, but I also know the administrative issues and the evidence handling issues that go along with the technical aspects of extracting digital information. So I'm approached quite a bit, as a matter of fact, on looking at evidence and how it was handled to determine whether or not it was problematic. Regardless of what you think of the defendant, and Mr. Raniere has a very bad reputation, thanks in large part to the how the media handled it. But he may be himself, a person with a lot of flaws. But if you don't have due process for people that you don't like, then we don't have a system of justice, right? But people approach me with these cases and they ask me to look at the evidence, look at how it was handled, chain of custody, communications between the agents, and I ask for these things. There are certain things that I ask for to determine whether or not due process was provided in this case with regards to the digital evidence. And there's a case I've had recently where I looked at it And again, it was the New York office, but it's a more recent case, and I can't find anything wrong that they did. I mean, from the time that they received the evidence from the person or the entity who collected it, from that point, I can see in the cart notes, in the chain of custody, in the image logs where they created the image, all of these dates line up, and so I know that the cart examiners in New York on that case did everything correctly. They immediately made a forensic image, and they put they put the original devices into evidence control. And it's right there in the notes. And I'm reading the notes, and I'm looking at the imaging logs, and I'm looking at the chain of custody and the communications between the case agent and the forensic examiner. Sometimes there are issues coming up. Well, are you sure this is within the scope of the warrant? Or is the warrant still good? Is it still in force? So they ask these questions. They asked all the right questions. They did all the right things. So in that case, I can't see anything wrong with what the FBI cart did in New York. So sometimes that's what I find.
So in the Raniere case, obviously you've described what occurred, didn't occur. In the Daedone and Cherwitz case, the way that the prosecutors handled what must have been apparent to them as some sort of major misconduct by McGinnis and Schmidt was to simply say, we're not going to offer that evidence. It's off the plate, and therefore you don't have an issue with how we did the case. But the truth of the matter is that the whole case against Miss Daedone and Miss Cherwitz was predicated upon that hard drive and the journals that McGinnis and Schmidt had received. So it's a case where clearly exculpatory evidence and misconduct were hidden in one fell swoop. I didn't want to let us finish before I mention at least one other thing, and we may have to have you back in the future to talk about this aspect of what you do. But you were involved in what we call the confidential human source, right? Explain what confidential human source, or is what we might call informants, is.
Yes, yeah. There are actually two types of confidential human sources. One is a confidential informant who is not expected to testify. And then the other one is a cooperating witness who is expected to testify. So those are really the two big buckets of confidential human sources. So a confidential human source that is expected to testify, we may wire them up and collect information that way, and interface with the bad guys. I mean, usually whether it's a confidential informant or a cooperating witness, a lot of times they are themselves criminals that have decided to cooperate with the government. By and large, that's who we have. It's in the technical realm. I've had myself handled some cooperating witnesses that technical. They're not criminals. They've seen something on their network. And I task them to continue to monitor what's going on in their network or in emails or whatever the case may be. And they're not criminals, but that's pretty rare, actually. So yes, so back in, I would say, maybe 2000, in the early 2000s, the FBI decided to kind of merge the confidential informants and the cooperating witnesses, and we call them all confidential human sources. And I was the confidential human source coordinator in Miami. We had a little over 600 of these FBI assets that worked for us in one way or the other.
And one of the things that you implemented in that role was to create a rating system to rate the sources, right?
Right. So in order to determine whether or not it's worth it to keep a confidential human source affiliated, with the FBI and working for us, and a lot of times we pay them, right? We make payments to them. We need to justify that. And every year, each confidential human source in the FBI is reviewed. Their file is reviewed. The information that they produce is reviewed, and that's done through something called a FOSAR, or Field Office. Field Office Source Assessment Review. I think I keep forgetting what the acronyms are. It's been a while, but it's a review of the confidential source, and so there are a lot of so you have to report on what they reported on, how useful it was, if it resulted in any statistical accomplishments like, dismantling of an organization or an arrest or a conviction or whatever it might be. You record those things. And then, we determine whether or not this person should continue on with the relationship with the FBI. None of these people are employees of the FBI, and that's all in the admonishment that we give them every year. You realize you are not an employee of the FBI. You are not allowed to do any unauthorized illegal activity, blah, 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 and they have to sign it, and that's done every year as well. So it's a very heavily monitored system of managing our confidential human sources.
Rick, we have other topics to talk to you about. We're not going to be able to do it today. I know we wanted to talk to you about, you mentioned monitors in the system who aren't criminals themselves. You yourself had an involvement in a whistleblower matter, but we'll talk about that on another occasion. I want to talk about the kind of things that we now see put on vehicles and how manufacturers are facilitating tracking people, building things into seats, into tires, etc. So on another occasion, we're going to get back into that. I so thank you for being here today. I consider you an invaluable source. I'm hoping others will find you as well. I know that they were fortunate in Raniere. Let's just hope the Court of Appeals does the right thing about that Brady. So thank you. And I say Brady information.
Right. Well, it's been fun. I appreciate it. I've enjoyed being here.
Thanks, Rick. We'll talk soon. Thanks.
Thank you.
So that's the end of today's episode. I'm hoping you'll join us next week as we continue our search into the criminal justice system and understand that we need your help in evaluating what we do. So if you can give us a like, comment, and subscribe to our podcast, that would be appreciated. Thanks so much. See you next week.
All right. Thank you very much, Robert. Take care.
Thank you.